Introduction. Sale of goods involves transfer of ownership. Risk prima facie passes with the property. If goods are lost or damaged, the burden of loss will be borne by owner of goods. Passing of property. Passing of property implies passing of ownership. If property has passed to buyer, risk in the goods is sold to buyer and not to seller, though the goods may still be in the seller's possession. Rules regarding transfer of property depends on two basic factors. 1. Identification of goods. Where there is contract of sale for unascertained goods, property cannot pass to the buyer unless and until the goods are ascertained. The buyer can get ownership right on the goods only when goods are specific and ascertained. 2. Intentions of parties. Property is transferred at such time as the parties to the contract intend it to be transferred. For ascertaining the intention, regard shall be to 1. The terms of the contract. 2. The conduct of the parties. And 3. The circumstances of the case. Primary rules for passing of property. A. Property, specific or ascertained goods, passes when intended to pass. Property in them is transferred to the buyer at such time as the parties to contract intend it to be transferred. Stages of goods while passing of specific goods when it is. 1. Specific goods in a deliverable state. Where there is an unconditional contract for the sale of specific goods in a deliverable state, the property in the goods passes to the buyer when the contract is made, and it is immaterial whether the time of payment of the price or the time of delivery of the goods, or both, is postponed. Here, the condition is goods must be ready for delivery. 2. Specific goods to be put into a deliverable state. Where there is a contract for the sale of specific goods, and the seller is bound to do something to the goods for the purpose of putting them into a deliverable state, the property does not pass until such thing is done, and the buyer has notice thereof. 3. Specific goods in a deliverable state. When the seller has to do anything thereto in order to ascertain price, where there is a contract for the sale of specific goods in a deliverable state, but the seller is bound to weigh, measure, test, or do some other act or thing with reference to the goods for the purpose of ascertaining the price, the property does not pass until such act or thing is done, and the buyer has notice thereof. B. Unascertained goods. Where there is a contract for the sale of unascertained goods, no goods is transferred to buyer unless and until the goods are ascertained. Following are the rules of passing of property of unascertained goods. 1. Sale of unascertained goods by description and appropriation. Appropriation of goods involves selection of goods with the intention of using them in performance of contract with the mutual consent of seller and buyer. The essentials are 1. There is a contract for sale of unascertained or future goods. 2. Goods should conform to the description and quality stated in the contract. 3. Goods must be in a deliverable state. 4. Goods must be unconditionally appropriated to the contract either by delivery to the buyer or his agent or the carrier. 5. Appropriation must be made by seller with assent of buyer or buyer with assent of seller. 6. Assent may be express or implied. 7. Assent may be given either before or after appropriation. 2. Delivery of the goods to the carrier. Where seller delivers the goods to buyer or carrier or bailee for transmission to buyer and doesn't reserve the right of disposal, he is deemed to have unconditionally appropriated the goods to the contract. See goods sent on approval or on sale or return. When goods are delivered to buyer on approval or on sale or return property, therein passes A. When he signifies his approval or acceptance or does any other act adopting the transaction. B. If he does not signify his approval or acceptance but retains the goods without giving notice of rejection, then, if time has been fixed for return, on the expiration of such time, and if no time has been fixed, on the expiration of a reasonable time, or C. He does something to goods which is equivalent to accepting the goods. Buyer under contract of sale or return is deemed to have exercised his option when he does any act exercising domination over the goods. Failure or inability to return the goods to seller does not necessarily imply selection to buy. Sale for cash only or return. Where goods have been delivered by a person on sale or return on the terms that goods were to remain the property of the seller till they are paid for. Property does not pass to buyer until the cash is paid for goods. D. Reservation of right of disposal. Right of disposal of goods to secure price before passing property to buyer. In case of sale of specific goods or appropriation, seller may, by terms of the contract, reserve the right to dispose of the goods until certain conditions have been fulfilled. In such a case, property will not pass till the condition imposed by the seller has been fulfilled. Circumstances under which the right to disposal may be reserved. 1. If goods are shipped or delivered to railway administration for carriage, and by bill of lading or railway receipt, the goods are deliverable to order of the seller or agent, then the seller will be prima facie deemed to have reserved to the right of disposal. 2. where seller draws a bill on buyer for price and sends to him bill of exchange together with bill of lading or railway receipt. To secure acceptance or payment, buyer must return the bill of lading if he does not accept or pay the bill. If wrongfully retains bill of lading or the railway receipt, property doesn't pass to him. Risk prima facie passes with property. Goods remain at seller's risk until property transferred to buyer unless otherwise agreed. But if transferred to buyer, goods are at buyer's risk whether delivery made or not. Exception to the rule that risk follows ownership. 1. Where delivery been delayed through the fault of either buyer or seller, goods are at the risk of party in fault for any loss which might not have occurred but for the fault. 2. Duties and liabilities of seller or buyer, as bailee for the other party, remain unaffected. Transfer of title by non-owners. General rule: seller cannot transfer a better title to buyer than he himself has. If seller is not the owner, buyer also will not become the owner. Latin maxim nemo dat quod non habet, which means that no one can give what he has not got. Exceptions: non-owner can convey better title to the bona fide purchaser of goods for value. 1. Sale by a mercantile agent. Sale made by mercantile agent would pass a good title in the following circumstances. 1. If he was in possession of goods or documents with the consent of the owner. 2. If sale was made by him when acting in the ordinary course of business as a mercantile agent. And 3. If buyer had acted in good faith and has at the time of the contract of sale no notice of the fact that the seller had no authority to sell. 2. Sale by one of the joint owners. If one of several joint owners of goods has sole possession of goods by permission of the co-owners, property is transferred to any person who buys in good faith and has no notice that the seller has no authority to sell. 3. Sale by a person in possession under voidable contract. Buyer would acquire a good title to the goods sold to him by the seller who had obtained possession of the goods under the voidable contract on the ground of coercion, fraud, misrepresentation, or undue influence, provided that the contract had not been rescinded until the time of the sale. 4. Sale by one who has already sold goods but continues in possession thereof. If such person sells them to third person, and if such person obtains the delivery in good faith and without notice of the previous sale, he would have good title to them. Pledge or other disposition of goods or documents of title by seller in possession are equally valid. 5. Sale by buyer obtaining possession before property and goods has vested in him. Where buyer with consent of seller obtains possession before property passed to him, he may sell, pledge, or otherwise dispose of goods to third person. And if such person obtains delivery in good faith and without notice of the lien or other right, he would get a good title to them. Exception: hire purchase agreement, which gives only an option to buy unless it amounts to sale. 6. Effect of estoppel. Where owner is estopped from denying seller's authority to sell, the transferee will get a good title as against the true owner, but the true owner had actively suffered or person authorized to sell the goods. 7. Sale by an unpaid seller. Where an unpaid seller who had exercised his right of lien or stoppage in transit resells the goods, buyer acquires a good title as against original buyer. 8. Sale under the provisions of other acts. 1. Sale by an official receiver or liquidator will give the purchaser a valid title. 2. Purchase of goods from a finder of goods will get a valid title. 3. Sale by pawnee can convey a good title to the buyer. Rules regarding delivery of goods. 1. Delivery of wrong quantity. Following are the cases subject to any usage of trade, special agreement, or course of dealing between the parties. Seller delivers a quantity less than he contracted to sell. Buyer may reject them all, but if buyer accepts the goods so delivered, he shall pay for them at the contract rate. Seller delivers a quantity larger than he contracted to sell. Buyer may accept the goods included in contract and reject the rest, or he may reject the whole. If accepts the whole of the goods so delivered, he shall pay for them at the contract rate. Seller delivers the goods he contracted to sell mixed with goods of a different description not included in contract. Buyer may accept the goods which are in accordance with the contract and reject remaining, or may reject the whole. 2. Installment deliveries. Buyer is not bound to accept delivery in installments unless otherwise agreed. Rights, liabilities, and payments thereon determined by parties. 3. Delivery to carrier. Delivery of goods to carrier for transmission to buyer is prima facie deemed to be delivery to buyer subject to terms of contract. 4. Deterioration during transit. The liability for deterioration necessarily incidental to the course of transit will fall on buyer, though seller agrees to deliver at own risk. Rule related to acceptance of delivery of goods. Acceptance is deemed to take place when the buyer I intimates to seller that he had accepted the goods, or 2. Does any act to the goods which is inconsistent with the ownership of the seller, or 3. Retains goods after lapse of reasonable time without intimating to seller about rejection. Buyer not bound to return rejected goods. Where goods are delivered and buyer refuses to accept them, Having right so to do, he is not bound to return them to seller unless otherwise agreed, but it is sufficient if he intimates to the seller. Liability of buyer for neglecting or refusing delivery of goods. When seller is ready and willing to deliver and requests buyer to take delivery, and buyer doesn't within a reasonable time take delivery, he is liable to seller for any loss occasioned by his neglect or refusal to take delivery, and also for a reasonable charge for care and custody of goods, provided nothing shall affect rights of seller where the neglect or refusal of buyer amounts to a repudiation of the contract.